Welcome back to another Tuesday Tips at 2. It's the spring, the weather's beautiful, the birds are chirping, the flowers are blooming, and yet we still got problems to discuss. In this week's edition, we're going to talk about that super long contract that you just had to take and you had to accept and had to sign off on. But now, what do you do about it because you're obligated under all those terms? Let's discuss. It's called a contract of adhesion, which means essentially you had no chance but to take it. It's a take it or leave it sort of offer. That's it. We got plenty of examples of it. For example, you go out to the ballpark, you buy a ticket. Well, that ticket has a whole lot of terms on the backside. Ditto with you buy a ticket to go fly from here to Abu Dhabi. You're basically obligated to whatever the terms the airline carrier is giving to you because you can't really negotiate with anybody. Is that the end of the story? No, it's not. My first bit of advice for this contract and all contracts is read. Just read the terms. You're human, you're literate, you're an adult, you're making decisions to accept the contract, so read what the contract is. I can't tell you how it drives me a little crazy to hear so many educated people, professionals, lawyers that come into my office and they're like, oh my God, I'm in this jam because of this contract. I mean, I didn't read it. Sure, I mean, who's got the time with all those pages and such? But hey, can you help me get out of it? Well, that's step one of the process. Read the contract before you actually sign it. Step two is make a decision, yes or no. Just because you want to do something doesn't mean that you have to do that something, okay? So read it before you get into it. Next up, let's say that you didn't read it. Or you read it, but you accepted it because you needed to go get that thing or you need to sign up for this app. It is what it is. I'm committed to it now. What am I going to do? But then, kablam! The problems arise. Whether A, you want to get out of a certain contractual term because you want to file a lawsuit, but this super long contract of adhesion had all this language that releases them out of any obligation, any liability, especially for injuries, or the opposite. You want to get out of the contract, and then the other side, the company that provided the service to the product, is suing you for trying to get out of this contract. And you're like, well, I don't like this contract. It's a super long contract. I didn't want this contract. And they're suing you for all this money. So under those conditions, the explosion has happened. You come to Danny, we're in a lawsuit over here, or maybe it's right before the lawsuit. What can be done? What can be argued? Not much, not much. Courts don't like to ignore contractual terms that people have agreed to. Courts and judges find that the path of least resistance is just to say, the contract exists, so just let's deal with it. But there are some decent arguments to be made. One is called parity of negotiation, an equality between the two negotiating partners. Here's a classic example. You got a contractor that comes on over because you need to fix the HVAC system or you want to remodel your bathroom. And then you get to talk to a human being about what the terms are and what you want and what the price will be. And when they get started up with stuff, that there is classic parity and equality of negotiating power. You know what the terms are, you know what you want, and you can talk to another human being, which is not the same when you're signing up for an app on your phone and there's no human to be talked to. There's not even a phone number that you can call up. And even if you do and you speak to someone at some call center in the Philippines, they don't have the power to negotiate with you. They might not have even read this contract themselves and know what it obligates you to. Well, that's step one. You can make that argument if you want to get out of one of these terms. Say, look, I didn't have a parity. I'm just a regular Joe here, okay? I couldn't have argued against this. Second point is to argue that you had no choice but to accept. I had to fly from here to Addis Ababa. That's what I had to do. So I had to get this ticket because this is the only airline carrier that was going to take me from here to Addis Ababa. What am I going to do? I had to accept it. That's a whole lot different than, for example, I'm flying from Houston to Dallas. There are 17 carriers that provide 37 flights per day. You got plenty of options there. Now, even then, it's an airline carrier, so you can go back to the same original argument of how perhaps there wasn't parity in negotiations. But those are two arguments to try to get out of not the contract as a whole, because judges rarely will allow you to do that, but perhaps one particular term of it. And still, you got to argue why that one particular term is against public policy. An example is you go out, you bring your kids to the fun bouncy house place, and they got all this release of liability language of how you can't sue them for any injury whatsoever. It doesn't matter how insane their employees work or how terribly and shoddy their equipment is maintained. You can't sue them. That policy, that term is against public policy, so you still need to make that argument, loop it on into the other ones of how I didn't have any other choice, I didn't have imperative of negotiating power. Those are some ways to deal with sticky long terms. Until next time, I hope you do tune in, and I hope that you have a wonderful, exciting, lovely spring up ahead. See you.